Okay. I'm sitting with my
Good
friends, and I see
afternoon,
Sentinel.
everyone. You can hear me? I'm Judge Phil.
Good afternoon, Judge.
Good afternoon. We're here for bond court. This is just a hearing to determine if there was probable cause for your arrest and to see if you're eligible to bond out. I've read the affidavits, and I'm going to call the docket in the order that my clerk gave me your file. When you hear your name, you'll come up. We'll see how quickly we can help you resolve your cases today. I don't know who you have at the podium there. Oh, going in order here?
This is Miss Rodriguez. She's on
Okay.
page 1.
Okay. Ms. Rodriguez, you're charged with domestic violence and driving with a suspended license. I found probable cause. I'm going to ask the state for the recommendation.
One moment, Your Honor. Do you have the PCs? Can you give me the PCs? Is it? Your Honor, frankly, I don't see any priors. I have no objection to even an ROR, just as long as they stay away from one another.
Contact?
That's what I would ask for, is no contact.
Okay, and it's a companion case, sort of Jorge Cruz? So,
Yes, Your Honor.
so what we're going to do is ROR Ms. Rodriguez with no victim contact.
Thank you, Judge.
Thank you, and so we need Mr. Cruz.
Good
Good luck. And same thing, state?
Yes,
Okay.
yes, Judge.
Hi, sir, how are you?
How you doing?
I'm good. You're charged also with domestic violence. The state's recommendation is to ROR, so we're going to do that with also an order for no victim contact.
Thank you, Judge. I'm going to explain to them what that all means.
Okay, great. Thank you. You know what? I'm going to call Jamie Fabre and Raymond Kirk.
They left everything else was reserved already. We got a table inside, it wasn't a problem. It was fun. It's funny, like, you don't Frank Meister.
Are you Jamie Fabre?
Does Peter
Can't hear
follow
him.
football?
Okay, sir, you bonded out, so just sit tight.
He's representing an all-pro
Okay, I
football
can't.
player from Carolina who's starting.
Turn the mic on, please. Push the button, sir.
And it's a guy's here with me.
Right in the middle, yeah, push it. You can push it.
I see the.
Perfect.
Hi, sir. Are you Mr. Fabre?
Yes, ma'am.
Okay, sir, you bonded out, so sit tight.
Thank you.
Okay.
You dare?
Raymond Kirk?
It's a serious heat. I'm not like
Yeah, I
saying,
know.
hey,
That's
you
why I'm
know,
calling him.
I'm not being one of those guys.
Hi, sir. Your bond was also posted, so just sit tight.
Like, Frank doesn't follow football.
Oops,
Just
yes.
football game watching the season. It's like, yeah, I'm handling the kids in Carolina.
All right, now we'll go back to the docket. Derek Jones?
I'm like, you're representing Frank, and like, what do you mean? He's like, now. It's like, yeah, it's a bit crazy. Just need attention. Like, yeah.
Mr. Jones bonded, Judge.
Oh, even better. Okay. Theodore Stacy?
He's present at the main, Your Honor.
Okay. Hi, Mr. Stacy. How are you?
You have a court date? Yeah.
Okay, sir. You have two cases out with a $500 bond each, so that's already been set, so we're going to leave it at that. And you have a status on 2/5.
It's Thursday.
Thursday at 10 o'clock.
You can pay the bond, but make sure you come to court on Thursday. Okay, down the middle, out the door. Thank you.
Thank you.
Hey.
Billy?
Mr. Billy is present at the main, Your Honor.
Hi, sir. You also have a case with a $500 bond, so we're going to keep that.
But, Your Honor, it's an MO, so maybe you want to put it to the side.
Oh, okay. Just have a seat. It's in a municipal ordinance, so we're going to do that in a few minutes. Jovan Argueta? You okay with the $100 bond?
Present at the main.
Hi, sir. How are you?
How you doing, ma'am?
I'm good. Sir, you're charged with resisting without violence. The bond's going to be set at $100. Okay?
All right.
All right, good luck.
Thank you, Judge.
Gary Signacki?
Present at the main.
Hi, Mr. Signacki. How are you? Could you hear me?
Turn the mic.
Yes, ma'am.
Okay. So you're charged with battery, and I found probable cause. $1,000.
Your Honor, I'm just making sure.
Sorry, I have a medical thing.
Looks like, he has a prior record out in New York, Your Honor, but I'm fine with the $1,000 bond. I would just ask for an order of no victim
Okay,
contact.
we'll do that. So we're going to set your bond at $1,000 with no victim contact. Aaron Johnson?
It's going to be at North Broward, Your Honor. He's on his way right now.
For Shinoki? Your Honor, for Mr. Singaki, requesting a
He's
photo
on his way.
order,
He's in North
Okay.
Broward. He's on his way right now. Okay.
Thank you.
I'll let you know as soon as he gets here.
Okay, for Mr. Johnson?
Yes.
Okay, thank you. All right, Mr. Clark, Anno Clark? So you have the order for the photo? Yeah. Hi, Mr. Clark, how are you? I don't think they can hear me. Okay, sir, you are charged with possessing a forged driver's license, grand theft auto, knowingly giving false information to a law enforcement officer, resisting an officer without violence, and possession of cannabis less than 20 grams. I found probable cause. I'm going to ask the state for their recommendation for bond.
Your Honor, he has in 2005, a strong arm robbery under a different name, so I'm just going to ask that the convenience bonds be kept in place.
Okay, so that's.
Your Honor, we're going to request counts 3 through 4 3, 4, and 5 be ROR'd and keep the bonds in 1 and 2.
No, I'm going to keep them as they are. I'm going to keep the convenience bonds as they are. I'm going to keep it 1,000 for count 1, 1,000 for count 2, and 3 through 5, 100 each.
Thank you, Judge.
Okay, thank you. Good luck. And Aaron Johnson?
Aaron Johnson, page.
Still waiting for him at North Broward.
Okay. So now we'll do our MOs.
Well, Your Honor, because we're still waiting on Mr. Laundere from Fort Lauderdale.
Oh, okay.
But we do have Roderick Rucker from this morning.
Okay, we could do that. Mr. Roderick Rucker?
Come on, Ruck. So, Your Honor, do you happen to have the docket from this morning?
Yes.
Okay, so there's at the outset, Your Honor, I would argue counts 2, 4, and 5 should be stricken as duplicative. There's only elements of counts 1, 3, 6, and 7. There's only one grand theft auto. There's only one alleged robbery with a firearm. I would ask the court to strike those as with no PC and ROR him on those counts.
I have no objection to for counts 2,
4, and
4,
5.
and 5. I have no objection to
Okay.
Thank you.
Okay.
Now, in reviewing the probable cause affidavit, my argument is this. First of all, as far as the grand theft auto, there is nothing in the probable cause affidavit to indicate that he knew or should have known that the car was stolen. Apparently, it's been missing since November, and that's fully 2 months ago. That car could have passed through any number of hands before it got to him. There's no way, nothing in this probable cause affidavit to indicate that he knew that it had been stolen when he received it. Nothing saying that it was started with a screwdriver, nothing saying anything about him knowing the car was stolen. So I'd ask the court to find no PC on that. Secondly,
Okay, wait, before you go ahead, I just want to tell Mr. Rucker, I don't know if this morning if he was told what the charges are, so I just want to tell him right now what they are.
I told him.
Okay, just to make sure for the record that sir, you're charged with robbery with a firearm, grand theft auto, and kidnapping an adult for ransom, and a violation of probation. Okay, so go ahead with your second point.
Okay. So we don't have anything on the VOP, obviously.
Right.
But the robbery with a firearm and the kidnapping, I took the time to run down the witnesses in this case. So you have two witnesses, two main witnesses, the alleged victim and another person named Crystal Fuller. The alleged victim is named Elijah Juan Zapport, Z-A-P-P-O-R-T. Now, Mr. Zapport was arrested in 2010 for burglary of an occupied dwelling. That case was ultimately declined. He was convicted of theft to appropriate in 2011, and he was convicted. He had an adjudication withheld on the delivery of cocaine in 2012. He may very well still be on probation for that. Crystal Fuller has a much more extensive criminal history. Grand theft to trespass in 2007, that was dropped. Burglary with assault or battery, that was transferred to another court. She was ultimately adjudication withheld on that charge. We have petty theft in 2012. And that's pretty much all. So now we have, and then we have the alleged co-defendant who has not been arrested yet, and he's got a record as long as longer than either one of these. So what we have here is a series of witnesses who are coming to the court with unclean hands, pointing the finger at my client for having committed a crime. Now, I can't argue against probable cause. The elements of these charges are in the probable cause affidavit. But what I can argue is that this is not proof evident, presumption great.
Your Honor, when you get done, I have
committed these
Aaron
crimes.
Johnson up at North Broward when you're done.
Thank you. Go ahead,
You're
counsel,
welcome.
sorry.
So proof evident, presumption great has to be something else. It's not probable cause. It's not beyond a reasonable doubt. It's something even higher than that. It's the highest standard we know. And for the court to find proof is evident, presumption is great. My argument to the court is that you would almost need something more than just the testimony of these convicted felons. You would need something corroborating that a crime actually occurred. And you don't have anything. Nothing coming from a third party saying, yeah, I saw this is what happened. Nothing coming in from someone that the court can find credible. And so while we can't argue against probable cause, we're arguing that this is not enough for the court at this juncture to find proof evident, presumption great. We're asking the court, under the circumstances, to find in favor of our client and set a reasonable bond.
Your Honor, I would argue that for counts 1 and count 6, that there is proof evident, presumption great. The investigating detective, Timothy Metz from the Broward Sheriff's Office, laid out the information he obtained, the information that was provided by the alleged victim and witness, the testimony from the witness corroborating a story that he was with him, that the defendant was talking about, that he had him, that the victim owed $500 for a stolen gun, the information from the victim, and both identify the defendant, satisfies the elements of robbery, firearm, and kidnapping. And there is an extra piece of evidence in addition to just their stories, and that is the defendant admits to doing this. He stated, and I quote the last page, that he states that he was forced by suspect Dennis to abduct the victim and orchestrate this ransom request. Now, he might be claiming someone forced it to him, but he does not deny that he did orchestrate the ransom request and assist in abducting the victim. That admission satisfies proof evident, presumption great because it corroborates the testimony from the victim that he was abducted. He was abducted. He was abducted, that a ransom request was made to his family members.
Okay, I agree. I think the proof is great, is evident, and the presumption of guilt is great. So I just want to know, counsel, for grand theft auto.
Your Honor, you know what? I'm fine with the court finding no PC and RORing him.
Okay,
I'm not going to ask for time to perfect.
okay. Okay, did you hear that, counsel? They're going to ROR on the grand theft auto. They're asking me to find no probable cause on that, so that's fine. But
Thank you, Judge.
I do find that there is probable cause and the proof of guilt is evident, or the presumption of guilt is great for counts 1 and 6. So that's going to be a no bond, and there's also no bond on count 7, which is the violation of probation charge.
We would ask the court to exercise its discretion in setting a bond pursuant to the Preston case on those 2 counts, 1 and 6.
And
I did.
Well, Your Honor, I would argue that,
You held them no bond on those 2, Judge.
and just for record purposes, my argument would be that actually the court does not have discretion. The court has discretion to set a bond if the state satisfies proof evident or presumption great at an Arthur hearing.
Yeah,
This is a first
I'm going to let
appearance.
the trial judge do that. It's a first-degree felony punishable by life. So the trial judge is going to determine your bond amount. Good luck, sir.
So that request is just for the record denied.
Correct.
Thank you, Judge.
It's a no bond, so it's no bond for both counts. For 3, for violation as well. All right. Okay, Aaron Johnson. Hi, sir, how are you?
Hey, Your Honor.
Okay, sir, you're charged with possession of cocaine. I found probable cause. Your convenience bond is set at $1,000. I'm just going to ask the state for the recommendation.
I'm just pulling his record real quick, Your Honor.
Okay.
Your Honor, his record includes 2008 fleeing or attempting to elude law enforcement, battery on a law enforcement officer, and resisting with violence. He was sentenced to 5 years in a day state prison as a prison releasee reoffender. He also had 2008 possession of cocaine with intent to sell or distribute, 5-year state prison. So we're just going to ask that the convenience bond be kept in place.
Okay, that's what I'll do. So it'll be a $1,000 bond. If you could post, you could get out today. If not, you'll see your trial judge in a few days. Good luck, sir.
All right.
Okay, so who's your client? Javier Williams?
No, that's a state charge, Your Honor.
Okay, Javier Williams? Maine? Hi,
He's
Mr.
right.
Williams, how are you? How you doing, sir?
Turn on the mic, Dill.
Sorry.
I'm doing all right, and you?
I'm good, thanks. Sir, you're charged with violation of probation for burglary of a convenience, and operating without a valid license and having an unlawful sticker. I found probable cause. Count 1 is a no bond hold, so that's what it's going to be. You'll be in front of your trial judge in a few days, and for counts 2 and 3, we'll leave the bonds at $250 each.
Judge, may I be heard?
I'm sorry?
May I be heard?
Is what? Leon County?
So, Mr. Williams
wait,
was here
I'm
this.
sorry, I didn't hear the clerk. Oh, okay, okay. But it's still a violation of probation, great. So, okay. Counsel?
Yes. So, Mr. Williams was reached out to the afternoon so that I could have an opportunity to explain to him what he is giving up by taking a plea. He tried to plead this out this morning in front of Judge Murphy. Judge Murphy wanted to make sure that he was properly counseled, understanding that if he were to actually plead the driving without a valid driver's license, that probably will violate his probation. He'll have no recourse when he gets up to Leon County. And he's been made aware of that. He knows that there's an admission as to this violation, and he's asking the court to go ahead and allow him to plead it
No,
anyway.
I'm not comfortable knowing that it's going to probably violate his probation, so I'm going to let the trial judge handle it.
That driving with no license and
No,
the
don't
other
say
that happened
anything
way
about
back
the
in
facts of the
2012.
case. You told him about that part, right?
Okay.
That's the old one.
Okay, just tell your counsel, not on the record. Okay.
How would that violate my probation when that happened way before I got on?
Thank you. Okay, Akeem Billy?
Judge,
Uh-huh.
I'm sorry. I'm looking at it again, and it looks like the case he's on probation for is a 2013 case, and the no valid DL and sticker attached is a 2012 case. So it actually would not violate his probation by pleading it out today.
Just gonna hurry up and get me.
It just gets him up to Leon County that much quicker.
Okay. They're not going to transfer him to Leon County? He's going to stay housed here for Leon. Okay. Did you hear the deputy? He's going to be housed in Broward either way for the hearing for Leon County. So it's not going to get him there quicker. Okay.
Understood. Thank you, Judge.
Okay,
thank you for
thank
considering.
Akeem Billy? That's an MO. Is it you? Okay. Yeah, are you counsel?
Judge Don Londeray. I'm here on behalf of the city of Fort Lauderdale, but I do cover for other cities when needed.
Okay. All right. So, sir, you are charged with, you have a KPS with a $500 bond. Your counsel is
Yes,
here.
ma'am.
You have any questions for your counsel?
Oh, Judge, I'm the prosecutor.
You're the, yeah. So where's the,
We're waiting on the big guy here anyways.
is the defense counsel coming?
You got it. I don't have contact. Who's this?
Okay, you want to sit in as a friend of the court? Okay. So you have any questions for counsel? Your bond is going to be $500.
Is this on?
I don't have any cancel, ma'am.
Well, you have someone here that's
on this docket or
going to
was this
help you
reset?
with it.
On the screen, sir.
$500. You can either bind up or stay in jail. Those are your two choices.
This wasn't on this document.
Okay? I'm going to set your bond at your bond is already set at $500. I'm just going to keep it
Okay.
that way. All right, good luck to you.
Here, I'm printing
No
out.
So then, Robert Torres and
30 days.
Jesse Pierre,
Is there
you're going to be ROR today? You're going to be released, Mr. Porras.
Thank you.
Okay, good luck. Is
Doesn't mean the case is over now. You got to check the mail and come back when you get your notice.
Yeah, I know.
Okay.
All right, Jesse Pierre.
Yes, John.
Hi, sir. How are you? Same
How you
thing.
doing?
I'm good. Same thing for you. You're going to be released, but you might get another court date, so just make sure you check your mail and come back if you do.
All right,
James
thank you.
West. Okay, James West.
Conti, Your Honor.
Thank you. Hi, Mr. West. How are you?
I'm fine now.
Okay, sir, you're going to be released today. You're going to be ROR'd, but you might get another court date, so just look for the notice in the mail.
Yes, ma'am.
Okay, good luck.
Thank you.
And William Mice. Mice. Where?
Paul Ryan.
Oh, okay.
All right.
Okay. Hi, sir. How are you?
Hi, Your Honor.
Okay, sir. You're going to be ROR'd. You're going to be released, but you
Okay.
might get a notice in the mail to come back to court. So just check your mail. Make sure and come
All
back
right,
if you get it.
All right, Your Honor, what address is that?
What address do you have? Well, give us
No,
your
yeah.
address so the clerk will know for sure.
Yeah, 4900?
Uh-huh.
Make sure you give it to the clerk, sir. They won't get it from here. Go to the office.
Okay.
Clerk right now.
All right, I'll give it.
You think so? You want to give it to the clerk now? I don't know. Okay.
But what is it?
Yes, I do.
4900.
4900 North Dixie Highway,
Uh-huh.
number 3.
And Fort Lauderdale?
That's in Fort Lauderdale. That's 33334.
Okay. Okay. Thank you.
All right?
Yeah.
Thank you.
Okay. Delmas Knight. Did we do that?
It's MO for
Conti, Your Honor. Conti.
That's an MO.
As MO, Sentinel. Yes.
Okay. So, sir, you're charged with soliciting in the public right of way. It's a misdemeanor. It's a municipal ordinance violation with a bond set at $150. I found probable cause. So, you have any different recommendation, counsel? for bond?
No, Judge, that's,
Any objection?
No, Judge.
Okay, we're going to ROR. We're going to give you time served. You can be able to get out today.
Thank
Okay.
you.
All right, good luck.
Judge,
Time served, sorry.
Time served, yeah.
Sorry. Okay, just so you know, this is, all right, and then we just have Stacy Issam.
Yes, ma'am.
What's your name? He's present, Your Honor.
Okay, sir, okay, so, you understand what's going on with this one?
Yes.
Okay. All right, Mr. Isom, you have a capias out for $500, but if you bond out, if you resolve it, you're a registered sex offender, so you might be subject to involuntary civil confinement. You understand that? Your counsel is here; he can explain it to you.
Do you understand what that means, Mr. Isom?
Yes. Yes, I do.
Okay. So our suggestion would be that you don't take any type of time served plea today. It'd be better for you to bond.
So I have to take the misdemeanor. So I have to take the misdemeanor to trial.
Not necessarily. It's better that you do not take a plea that keeps you in jail.
It's better you go before your trial judge.
So I have to stay in jail.
Or you can
Well, you
bond.
don't have to.
You can either bond out or.
So I have to bond out.
Judge, could we possibly lower the bond for prosecutor? I think, Mr. Isom, are you indigent? Are you
He was
homeless?
picked up on a capias.
I'm indigent and
Capias,
homeless.
I can't change it, counsel.
I'm sorry, Judge.
Yeah, no, just so you know, it's a
Okay.
capias, that the bond was set already, so I can't,
Okay, I apologize.
and it wasn't my capias, or else I
Judge,
could
I have
change
the
it.
paperwork, he didn't have it, that's why.
Okay. So,
That was nice.
should I get that?
Yes, I'm indigent
Okay,
and
okay,
homeless.
Is this the court? Yes, this is court? This is courtroom 235, we're in the middle of proceedings.
Yeah, that happens sometimes.
Okay, all right, sir, so, the bond is set for $500, but if you do, take it because you're a registered sex offender, it could subject you to involuntary civil commitment. You understand?
Okay. Yes. So how long does it take for me to see a public defender or whoever's gonna defend me?
He's right
I'm
here.
standing right here, sir. I'll see you in court. I'm gonna try to, when I go back to my office, I'll try to set your hearing date as quickly as possible.
Okay.
Okay?
Okay, so we're gonna leave it at 500. All right, thank you. Thanks, counsel. Thanks, sir. Good luck.
Okay. We're clear at the main.
Okay, we're all over. Over and out. All right. Thank you, everyone.